All right, well, please join me in welcoming this first panel. As I indicated in my introduction, the panel will be talking about what is a court-appointed neutral. Our panelists include Leslie Berkoff, you've heard from Michael Cardello, her partner, ran into an unfortunate last-minute professional conflict, but we're very grateful to have Leslie here representing everything that he would have said, and with or without authority. To Leslie's left is Roma Petkauskas, and Roma, thank you again for joining the fray. To Leslie's right is Merril Hirsh, whom I've mentioned, and to Merril's right, Ed Gentle. And so with that, please take it off.
Thank you very much, and thank you so much for all your work on this bill. I'm Merril Hirsh, and this first panel involves the most frequently asked question I get in life, I think, is what in the world is a court-appointed neutral? And I am pleased to be with some wonderful experts with experience in this. I will give a little introduction, which may help frame a little bit about why this is the first ever court-appointed neutral ethics meeting and why the issue is so challenging for some of the other panels. A court-appointed neutral is a Swiss Army knife. It is a panoply of different tools that a court might potentially want to use. The most common example, particularly in New York, people think of as kind of apt is today happens to be Ken Feinberg's 80th birthday. And people think of the 9/11 fund allocating the funds. That's not actually a court-appointed neutral because it was established by Congress. But the idea of using a neutral to figure out how to allocate a fund is one of many, many things a neutral might get used for. That makes it one. There are actually dozens. In fact, it is a concept limited only really by our creativity. The idea of a court-appointed neutral is, how can someone help? How can they help solve the problem? The most common name given to this, one of dozens, is special master, which further confuses it because A, there are dozens of names and nobody can sort out all the different names. Believe me, I've tried. And B, once you attempt to sort through it, you realize that of all the possible names you could call, this special master is about the worst choice. Not only because it's a lousy term for somebody who a court is invested with authority, but also because it says this is someone brought in to take over when what you're trying to describe is someone brought in to help. No one really likes having a master except maybe a St. Bernard. And so the problem with it is this is a role that could be quasi-adjudicative. It could be someone brought in to handle a whole bunch of discovery motions by a poor judge who's pulling his or her hair out in frustration, telling them to go to their mother or a court-appointed neutral or somebody. But it could be a purely facilitative job. Help these parties work this out. Help them figure out how they're going to do their e-discovery or how they're going to exchange information or what information they might need to help discuss settlement and not necessarily to fight each other in litigation, or to provide some expertise to walk in and with an experience in, say, business valuation or forensic accounting or nuclear physics, if that's what the case requires, or any other skill that someone might have. So that role is not quasi-adjudicative. It could be facilitative. It could be advisory. Help me figure out what these technical terms are in a patent. Help me figure out what's junk science. It could be investigatory. Go to this prison and do a report back on what the conditions were, or go figure out where the money went from a trust. It could be an oversight role. Help monitor this decree and make sure it gets enforced. It could be something that insulates the process in a way that improves it. Go on the execution of a warrant of a law office and make sure that the law enforcement people don't see attorney-client privilege information, or review a government's Brady disclosure and make sure they've done it properly. It could be any number of things where you're taking advantage of neutral skills which combine often backgrounds in alternative dispute resolution, and often backgrounds in technical fields, cybersecurity, database management, science, whatever. Often the best thing to have is sort of a two-factor identification. You know, I'm a mediator, but I'm also a, rocket scientist or whatever it is. And the challenge that presents for ethics is great. You know, we all know it's perfectly simple to figure out lawyer ethics. Lawyers just do one thing, right? So nobody ever argues about that. No, I mean, lawyer ethics are complicated enough. It's perfectly simple to do mediator ethics. Well, all right, there are books talking about for one that Kristen worked on, who will be on our next panel, for the DR section, talking about how difficult it is to sort out mediator ethics. There are endless discussions about arbitrator ethics. Imagine a job that could involve aspects of all of those different things in different roles at different times. And you realize the challenge in taking on ethics. So where this program comes from is, as Bill mentioned, Bill is the chair of the ethics subcommittee of the Judicial Division Lawyers Conference Court-Appointed Neutrals Committee. Now, this is one of these ridiculously long names with no known acronym, but, it's a committee set up to look into how could we make better use. And what Bill has spearheaded with other people you'll be hearing from today are efforts to try to sort all this out, figure out what the best way to sort it out, figure out how to get ideas out there so people can discuss them and think about it, and so that we can establish the standards, as you heard Debbie Greenspan's introduction, the standards that set a profession and get us to understand it. Now, with me today, with that introduction, you've had a little bit of introduction, so I'm not going to spend a ton of time. But Roma is a partner in BrownGreer in Richmond. She does claims administration. She spent years in New Orleans, setting up like 18 claim facilities for the BP oil little situation that they had there. And Leslie Berkoff, you've heard, is a partner with Moritt, Hock, and Hamroff. She is a mixture of one part ADR professional, one part bankruptcy restructurer, one part litigator, and then a few other parts that I haven't quite fit together, but a tremendous occasion. Ed Gentle is one of the best known neutrals in the country. He has worked in dozens of cases. He is the consummate, perfect country lawyer with a Rhodes Scholarship, and one of the most articulate spokesperson and thoughtful people in the entire field, a former president of the Academy of Court-Appointed Neutrals, among others. So with that, Roma, why don't you talk about what kinds of roles you think about as a court-appointed neutral and how you think about the story?
Hi, everyone. As Merril mentioned, I focus primarily on the claims administration, have been doing this for decades now. And claims administration is a little bit of an adjunct in the neutrals world. And it's a catch-all phrase for the many fascinating things that the claims administrators are entrusted to perform. So I'll stop for a moment and cover some of the things that I was fortunate enough to do in my career. As Merril mentioned, working on the BP oil spill, I ended up in the Grand Isle, which is a beautiful little island, and was meeting the claimants who were affected by the oil spill, who were working in the on the beach, would meet me with their boxes of papers and asking me to take their claims, and delivering that justice to the people right there on the beach was an empowering experience. Working on the implementation of the national opioid settlements, my claim to fame is that we almost broke the Fedwire system because we issued so much payments in one day to the affected claimants. And then with Ed Gentle, we ended up in Pensacola one day trying to convince the claimants who were not have not decided whether to join the claims program that we were administering. And we spent a day talking to them, explaining to them the terms of the settlement program and seeing if they want to be part of it. So I just touched on a couple things that as a claims administrator, I do every day. It's, again, a fascinating field. The cases that we administer, the NFL concussion settlement, the BP oil spill, the Fire Victims Trust bankruptcy, are the names of the programs that you read in the news. There is huge scrutiny. There are lots of claimants that we have to deliver their benefits to, and it's a job that I employ all my skills every day. I do not know what the day will bring. Typically, my to-do lists go away the minute I log in and see all that has come in that day. But just think about that. You have claimants who are underage. You have claimants who are undergoing bankruptcies. You have claimants who invested and believe that this product, this wrongdoing is what caused the probably worst event in their life, and they want to be compensated for it, and they want it to be done quickly, and it's a huge responsibility. So the way I had come to see my work is we have to be transparent, and we have to deliver the benefits or resolution. Sometimes the denial of a claim is all that is needed for the claimant to have a closure. So we move through this process as quickly as possible and as transparently as possible. But now, with all that said, I'll stop and ponder for just a moment about the ethical challenges that will be covered in the upcoming panels. And I want you, Ed, to jump in because we face the same challenges day in and day out. But just to focus us in, my work starts when there is a settlement. And a lot of judges will congratulate the settlement and almost see that as the end of their involvement. So then there's this immense responsibility given to the claims administrators to manage millions, hundreds of millions of dollars to deliver the benefits without really significant oversight in a lot of the programs. And then when you think about that, well, I'm a lawyer. I practice in a law firm, but many of the other claims administrators are not even law firms. So to the extent I'm governed by the ethical rules applicable to the lawyers, which are not really applicable to the claims administrators, not everyone in my profession is. And so then you have all the different and interesting nuances that develop as challenges. Wouldn't you say that?
I'm going to chime in. Okay, so this is especially true for settlements with a long tail. For example, medical monitoring, maybe 30 or 40 years. And not to disparage anyone, but settlements have a way of allowing the plaintiff lawyer to back up to the pay window and leave. And then we have 30 years to go. The defendant, of course, especially with a pay-go settlement where the defendant replenishes, the defendant is very active and very much an advocate, but there's no pushback from plaintiff's counsel. And so that's a big ethical issue. And, you know, one way to do it is to pay the lawyers as the remedy rolls out. Another issue you have is sometimes when administrators are appointed by the court, and there's different levels now. There may be one that manages the qualified settlement fund, one that handles the liens, one that makes the payments. You know, there's a possible MDL on the horizon about some payments that weren't fully disclosed, perhaps, and not monitored by the court. My real question there is, where were the lawyers to monitor that? Did they back up to the pay window and leave? Or did they fulfill their ethical obligation to maximize what the claimant gets to the mailbox?
Mm-hmm. And the competency, too, and the standards of what are the best practices in claims administration is also part of the ethics, because competency is one of the bedrocks of the profession. And so those standards vary greatly. And in many instances, the unfortunate may happen where we get a call to rescue a program where it wasn't successfully being implemented. So this is not to this is just to encourage the further discussion on standardizing and shining a little bit more light into the ethical questions. And where I come to it is I think what I heard you, Ed, kind of conclude is oversight. I would encourage the oversight from the presiding judges who typically retain exclusive jurisdiction over the case and the settlement. And so regular reporting and the role in the selection of the claims administrator and oversight, I think a great way to ensure that there is someone watching and being holding accountable the claims administrators. And I come to that conclusion because I don't think that, as Merril said, there are all these different neutral roles and different rules. So you either have one set of rules for the claims administrators, or you have someone who is watching. And I think the judge presiding over the settlement would be the best person to ensure transparency, accountability, and due process.
Leslie, do you want?
Let me, oh, wait a second. So as Merril mentioned in his introduction, I'm a bit of a Jill of all trades. And so part of my practice is serving as a chair of my firm's DR department, but as a neutral, a mediator, an arbitrator. Part of it is serving as a bankruptcy litigator. And part of it is serving as sometimes a receiver. All of those themes, if you would, actually take me between a variety of courts and actually lead me to a variety of different court-appointed neutral roles, which vary tremendously. So I'm going to just sort of identify some of them that people may actually not be familiar with, or perhaps you are. So we've talked a little bit about what we used to call special masters. I've been appointed by judges to be a books and records referee, or a discovery referee, which basically means in one instance as a books and records, you're just making sure the parties have a process, that you oversee the process, and make sure that they exchange that which they are supposed to. A discovery referee is a little broader than that. You're taking it out of the court system or the court's purview directly just so that they don't have to deal with the warring parties. The judge is still there. We report back to the judge. The judge is there to enforce any orders that are issued. The interesting thing is I can issue orders as a referee, but to compel enforcement or to sanction parties for not complying with them, we have to go back to the court. So I am an arm of the court. I'm responsible to be an adjunct to the court, but the court is there to oversee and back me up and make sure that people do what I tell them they are supposed to be doing. And I'm neutral because I'm not there to side with one party or the other. I'm there to facilitate a process and to make decisions or set of processes in place and to sort of remove the fray from the court. It helps a couple of things. In some respects, the judge doesn't get to see all of the nonsense, and quite frankly, a lot of times it is nonsense. I have parties in what I was appointed to, they're fighting over who I'm letting on the call. I mean, that's the level of nonsense. It's very helpful. Then you have things such as an examiner. So in that capacity, for example, there is a large series of very well-known nursing home case. I've been appointed by a federal bankruptcy. I'm an examiner. I am there to understand what happened to assets, claims, money prior to a bankruptcy filing. I'm there to investigate. I will take my own independent discovery, but my responsibility is to report back to the court. I'm neutral. I'm supposed to tell the court what I think happened. I'm supposed to tell the court or identify claims for the court, and then the court will decide who gets appointed to proceed to perhaps pursue those. That will not be my role. I am neutral. I am simply an investigator. I've been appointed by a state court judge to be technically a receiver of an entity, but the role was defined differently. And this is where you get into these, what I call multiple hats or Merril calls the Swiss Army knife. So technically, I was a receiver. I was responsible for the facility itself. I was responsible for making sure that the bills got paid, all of these things happened. But the charge was very direct. I was to commence a forensic investigation going back 12 years to see what happened and report back to the court what happened between these entities, what happened to lead money to go out the door. I worked obviously with a forensic accountant on this, but the overarching reporting and analysis was mine. I have been appointed sometimes as a receiver of an entity, and I have had a judge say to me, I'm asking you to be receiver. I'm asking you to manage the entity and probably liquidate the entity. But if you could take your other hat as a mediator, and if you think it is opportune and you can get them to stop killing each other, the court would greatly appreciate that. And I stepped in and out of the role to some extent of mediator. I attempted to avoid having to liquidate the business. I could not get the parties to see reason. We liquidated the assets of the business. And then when we had a pool of money and we had a pool of claims, I brought them back and I was able to settle the case. So those hats were on and off. And it changes the role that you have in your engagement with the parties, and you're walking different lines. As a receiver, my charge is somewhat to the creditors of the entity. But when I'm then trying to deal with the parties, I've now refocused my energy on their disputes between each other. And there's a tension that I have to be mindful of, that whatever I'm doing to resolve it is not in conflict with my initial charge to liquidate the assets out. There are other things when we come to bankruptcy courts that are unique. There are patient care ombudsmans. There are privacy ombudsmans. There are monitors. Monitor doesn't just exist in federal court, but sometimes you are put in to oversee, similar to what you were talking about, the process, the procedure, because a court can only get so involved. Let's be clear. Judges have settlement conferences or they bring people in for status conferences, but there are a lot of things that happened in between those conferences. And in certain cases, a court may need somebody neutral to supervise, make sure things are going the way that they should, and potentially report back. And depending on the role you're holding, the ethical issues come up, because some of what you're doing, if you're sitting specifically as a mediator, what I'm reporting back to the court is very generic. We had a mediation session. This is who attended. We did or didn't settle. There's some shades of gray in there, maybe a little bit more, but you're very mindful of all of that.
Pardon me for my first code interruption at the midpoint of this presentation. And the code is Swiss Army knife. Swiss Army knife.
See a theme there.
Yeah, I don't know where he came up
I
with
don't
this stuff.
know. So for 1 second, I think I've covered a fair amount of them. What I would say to you is Bill referred to the competing program, which is the ABA Mediation Institute, which technically I'm the planning committee for, and I spoke yesterday on. And we did hard skills of mediation, but in my breakout session, my facilitated program, we talked about ethical issues that confront just the mediator. We were very focused on that. And there really are things that you have to consider and think about just in that segregate area of how you're guiding the parties, what you're saying to the parties, things like puffery. Lawyers can pound tables and lawyers have certain things that they can say and do. But a mediator also has to be mindful when we are looking to guide the parties to a settlement and encourage them of risks and rewards, or where the other side may or may not go. There is a line that could be crossed if you are not careful. In the desire to resolve a matter, there's something called puffery, and you cannot do or go as far as a lawyer advocating could, because they can bluster a little bit more for their client, but there are all of these fine lines. And what I would say, and then I'll turn it over, is I think the most complicating piece of ethics in these areas is because our roles are somewhat fluid and sometimes can change. It's really hard to draw a very bright line. It's always hard to draw bright lines on ethics when you sit in this much more slightly amorphous role where at times, like I've given you an example, you're switching hats. it's very, you have to sort of try and sometimes just figure out in the moment, where is a bridge too far? Where is my rule? And there are not always guideposts almost as clearly as they are when you are an advocate.
Just to comment on that for people who haven't seen it, the ABA issued a formal ethics opinion on this, what, week and a half ago or something, that I thought was somewhat eye-opening, frankly, from the perspective of what happens in mediations as to the limits on what a mediator can do. You know, you have an obligation to be honest. So if you walk into a room and you tell somebody their case is worthless when you know it's not, are you being dishonest? Or are you just trying to twist their arm? And how far can you go on that? It is a very interesting, take on that I think is different from at least a fair amount of the practice I've seen. Well worth reading.
I think, if I'm not wrong, it's 518 is the number?
518, I think is the
518, I
number.
commend
Yeah.
that to you. It's ABA, yeah.
Ed?
I'd like to make a couple points. First of all, I think there's one ethical lens that's not represented here today, and that is accounting. A lot of what we're talking about exceeds the practice of law. Certainly, claims administration is way beyond the practice of law. And one of our challenges is to prevent what? Waste, defalcation, and fraud. So as an example, when Roma and I were talking about some claims administrators that maybe kept some money they shouldn't have, there are a couple really simple solutions. Do a detailed annual fiduciary accounting to the court, age that with the parties, and get it approved. There's your shark repellent. Get with the CPAs and let's create a FASB on what the rules of the road should be for claims administration financially. And so that's just a couple of examples of how perhaps accountants need to be represented at this ethical seminar in the future. I want to get really maybe to one of the big punchlines of this presentation, and that is, how do you become a special master or court-appointed neutral if you want to be one? And I think the answer is to swim with a friend, and that is get to know some neutrals and hang out with them. Kind of like in your practice of law. What's the biggest source of new work? Other lawyers. What's the biggest source of special master or neutral work? Other neutrals. And what happens, for example, and I can think of 3 MDLs where this happened, the Rejuvenate hip case with Judge Frank, the breast implant case with Judge Pointer, and the Blue Cross case with Judge Proctor. You're the ombudsperson, I think, as the other presenters said. The court has a new problem and wants you to help them, but a lot of times it's beyond your time or your ability. So get someone else to help you. For example, in one of the opioid cases, a young special master that belongs to ACAN is now going to be the guardian ad litem for the NAS children. They're minors. They can't decide what to do with their money just because we have a training program. And she was my adoptee, and it worked out great for her. So I would just suggest those 2 points.
Okay. We have a couple minutes left. We can talk a little more about roles. Well, actually, one I would like to mention, since Leslie's partner, Michael Cardello, didn't get a continuance of a trial, strangely enough. I mean, who imagined?
He's in the middle of settling it. He hasn't seen the light of day in 3 days.
Yes, I've heard tell that like he hasn't slept or whatever. So
It's good for him. It builds character.
yeah, it does build character. But
That's what the track coach.
yeah, that's what the track coach said. But what Michael, who is on this panel, his focus is quite different from any of the other people. He is a neutral whose work involves primarily dealing with lawyers behaving badly in discovery disputes. And it's a whole aspect of why courts might want to use a neutral, because really, courts don't have the time for this. But put aside have the time, think about, the reason this comes out of it. One of the confusions about the job is, are you, doing something a judge should be doing? But if you think about, for example, how the 2015 amendments to the Federal Rules of Civil Procedure were structured, they were structured with an idea that lawyers were supposed to be responsible for the just, speedy, and efficient resolution of every action. And that was put into Rule 1, so therefore that instantly solved it, and lawyers would never be inefficient or unjust or less than speedy. the thing is, it's not self-executing, but the philosophy of the rules is, you know, most of the stuff shouldn't reach a judge's desk. Judges should actually, you know, their primary role is not herding cats, and it's not better for the world to have them herd cats. And so what Michael does, a lot of it at the state, you know, at the state level, is judges bring him in to help herd the cats, to help get them to work more effectively, help them save money with their clients, you know, and do this. You issue in a discovery role, you will issue orders. The orders are all reviewable by the judge, but it's usually in the form of an order. People are expected to respond unless they get the judge to stay it, and you take that role in order to make it more effective. One of the things is we'll turn to the other panels about how these other roles, if you think about it, and Ed threw in the world of accounting, there's also, of course, judicial ethics, because a court-appointed neutral is an officer of the court. So as an officer of the court is responsible to make sure that the code of judicial conduct is followed. And so there's a responsibility to the aspects of that code. If the person's a lawyer, there's a responsibility that you continue to follow your ethics as a lawyer. You don't give them up just because you happen to be a court-appointed neutral today. If you're dealing with mediation or arbitration issues, there are guidance that you're following that. As Ed pointed out, if you're a certified public accountant, which Ed, by the way, also is, he has responsibilities to accounting ethics. So the complications are multiple roles and multiple regimes of ethics that were adopted for different purposes besides someone sitting as a neutral and helping to work, you know, through these. So are there any questions? We have a couple of minutes before the next panel. I'm happy to turn it over, but there's one there I see. Yeah, can you go up to the mic?
Good morning.
Good morning.
I'm Jill Pilgrim. I'm the immediate past chair of the New York State Bar Dispute Resolution Section.
That's
Leslie
terrific.
represented us very well in the intro. I don't know if you were planning to get to this later, but as we sit here during a federal government shutdown and we're talking about neutrals, I just thought it might be interesting to know how does one get compensated when there's not a shutdown, but also is the shutdown impacting neutrals getting paid for all the different roles that you're talking about? How do we get compensated in all those different roles?
Okay. Well, one of the issues with neutrals, the vast majority of time, but it's different in somewhat different settings, they're paid for by the parties. It is a factor of the order in which the neutral is appointed. The order will specify what the neutral is supposed to receive, and that's one of the concerns in appointing a neutral, that the neutral return value that justifies the compensation. If they're being paid by the parties, I mean, I suppose a party can say, well, the government's shut down, I don't want to pay you, but I kind of doubt that works. However, there are other settings. It's a complicated story in bankruptcy because there's a bankruptcy rule 9031 that we're trying to get changed that prevents the use of court-appointed neutrals in bankruptcy in that situation. However, do you want to talk about this other?
Yeah, just so the answer is in bankruptcy, yes, it does for the following reasons. So in my examiner role, the parties are indirectly paid. Oftentimes, if I'm not sitting as a mediator in bankruptcy, if I am a court-appointed neutral, such as an examiner or a monitor, I'm being paid effectively by the bankruptcy estate, the debtor and the bankruptcy estate, which means there's a fee application. The Office of the United States Trustee is an adjunct branch of the Department of Justice. Right now, if you have a pending fee application, the Office of the United States Trustee is not operating. They cannot review it. There is no judge that is going to approve a fee application until the governing supervisory branch of the UST reviews it. So all fee applications are being kicked. So in that capacity, the government shutdown is impacting you as a neutral. It's also impacting all the professionals that need to be paid, but as well, all of our fee applications have been postponed.
It's also affecting the courts themselves,
Yes,
too.
absolutely.
I mean, the courts are under a tremendous strain in how to meet things while there's a government shutdown. And that has ripple effects for everyone involved in federal stuff. Obviously, you know, federal is a part of the world. It's not the whole part of the world, so that's another issue. But, you know.
You tell that to a federal judge, but
No,
okay.
no, I mean, one thing to understand about the job that's worth considering on the roles and what people get involved in, because people don't think about this. Federal litigation, obviously, is very important in our country. There are 600,000 cases filed in federal district court each year. There are, however, 66 million cases filed in state courts in the United States each year. And even if you exclude traffic, that leaves you with about 33 million. You're talking about orders of magnitude more law gets practiced in state court than the federal court, where 3/4 of the cases involve at least one self-represented litigant. So the challenge for a court-appointed neutral in being appointed to be in an antitrust case or an MDL in federal court is a little different than the challenge of helping in family court in, you know, we're self-represented litigants. That's a tremendously important need for neutrals in access to justice. All right, I think we're at the end of our 11 o'clock, so
pulled.
cool. We're being pulled. Here comes the
Please
vote.
join me in thanking this wonderful panel. I think this panel did a great job in introducing us to what is a court-appointed neutral. Some folks might refer to shorthand as CAN, C-A-N, for court-appointed neutral. Not everyone likes that shorthand. But here's your next code word for folks participating remotely. It is you, as in Y-O-U, can do it. You can do it. So that's the code word, and I'm going to invite the next panel to join us.